Question 1. The efficiency study reveals that a Kansas real estate licensee is tasked with providing a valuation for a standard single-family home that is being listed for sale. The client has requested a valuation that will be used to set an asking price and potentially for mortgage lending purposes. Which appraisal approach would best meet the client's needs and regulatory expectations in Kansas? Option A. A full residential appraisal, involving a thorough interior and exterior inspection of the property and detailed analysis of comparable sales. Option B. A desktop appraisal, relying primarily on publicly available data and automated valuation models. Option C. A commercial appraisal, focusing on the property's income-generating potential. Option D. A drive-by appraisal, consisting of an exterior inspection and limited data collection. The correct answer is A. A full residential appraisal, involving a thorough interior and exterior inspection of the property and detailed analysis of comparable sales. Explanation. The efficiency study reveals a common challenge in real estate appraisal, balancing the need for timely and cost-effective valuations with the requirement for accuracy and regulatory compliance. This scenario is professionally challenging because a licensee must determine the most appropriate appraisal type for a given situation without compromising the integrity of the valuation or violating Kansas Real Estate Appraisal Commission (CREAC) regulations. Misjudging the required level of detail can lead to inaccurate market assessments, client dissatisfaction, and potential disciplinary action. The most appropriate approach involves selecting an appraisal type that aligns with the property's complexity and the intended use of the valuation, adhering to CREAC standards. For standard single-family residence, where the client requires a comprehensive understanding of market value for a potential sale, a full residential appraisal is the best practice. This method, which involves a thorough inspection of the property, detailed analysis of comparable sales, and consideration of all relevant market factors, provides the highest level of accuracy and meets the typical requirements for mortgage lending and general market valuation. CREAC regulations, while not explicitly dictating specific appraisal types for every scenario, emphasize the need for appraisals to be performed by qualified individuals and to be sufficiently detailed to support the opinion of value, especially when used for financing purposes. A full residential appraisal ensures this level of detail and reliability. Performing a desktop appraisal for a property that requires a physical inspection to accurately assess its condition and features is a significant ethical and regulatory failure. Desktop appraisals are typically suitable for situations with readily available data and minimal physical variables, such as portfolio valuations or certain refinancing scenarios where the property's condition is well documented. Using it for a standard sale without a physical inspection risks overlooking critical factors affecting value, such as deferred maintenance or unique property characteristics, thereby providing a potentially misleading valuation. Similarly, a drive-by appraisal, which involves only an exterior inspection and limited data gathering, is insufficient for determining market value for a typical residential sale. It lacks the depth of analysis required by CREAC standards for most transactional purposes and would likely fail to identify significant value-impacting issues. Relying solely on a commercial appraisal for a residential property is also inappropriate. Commercial appraisals employ different methodologies and focus on income-generating potential, which is not the primary driver of value for a single-family home. This misapplication of appraisal type would lead to an irrelevant and inaccurate valuation. Professionals should approach such decisions by first understanding the intended use of the appraisal. Is it for a sale, a refinance, an estate settlement, or a tax appeal? Next, they must consider the property type and its complexity. A standard single-family home generally requires a more detailed appraisal than a vacant lot. Finally, they must consult relevant CREAC guidelines and ethical standards to ensure the chosen appraisal method provides a credible and defensible opinion of value that meets all regulatory requirements. Question 2. Regulatory review indicates that a loan originator, licensed as a salesperson in Kansas, is facing pressure from a client to expedite the closing of a mortgage loan due to a time-sensitive purchase agreement. The originator has identified a few minor discrepancies in the submitted financial documentation that, if fully investigated and resolved, could delay the approval process. What is the most appropriate course of action for the Kansas licensed loan originator to optimize the loan approval process while adhering to regulatory requirements? Option A. Expedite the approval process by overlooking the minor discrepancies in the borrower's financial information, assuming they are not significant enough to impact the overall loan risk. Option B. Conduct a thorough review of all submitted loan documentation against established underwriting guidelines and Kansas lending regulations, and proactively communicate with the borrower and relevant parties to resolve any identified discrepancies or missing information before proceeding with the approval. Option C. Approve the loan based on the borrower's verbal assurance that the missing documentation will be provided immediately after closing, and proceed with the closing to meet the client's deadline. Option D. Submit the loan for approval with the incomplete documentation, with the intention of obtaining and correcting any outstanding issues after the loan has been conditionally approved. The correct answer is B. Conduct a thorough review of all submitted loan documentation against established underwriting guidelines and Kansas lending regulations, and proactively communicate with the borrower and relevant parties to resolve any identified discrepancies or missing information before proceeding with the approval. Explanation. This scenario presents a professional challenge because a loan originator, acting as a Kansas salesperson, must balance the need to facilitate a loan closing with the absolute requirement to adhere to underwriting standards and regulatory compliance. Rushing the approval process to meet a client's perceived urgency without proper due diligence can lead to significant legal and ethical breaches, potentially resulting in financial harm to the borrower, the lender, and reputational damage to the originator. Careful judgment is required to prioritize regulatory adherence and sound lending practices over immediate client satisfaction. The best approach involves a thorough and documented review of all submitted loan documentation against established underwriting guidelines and Kansas lending regulations. This includes verifying income, employment, assets, and creditworthiness. If any discrepancies or missing information are identified, the originator must work collaboratively with the borrower and relevant parties to obtain the necessary clarifications or documentation before proceeding. This methodical process ensures that the loan is approved based on objective criteria and complies with all applicable laws, protecting all stakeholders. This aligns with the principles of responsible lending and the duty of care expected of licensed loan originators in Kansas. An approach that involves approving the loan based on a verbal assurance from the borrower regarding missing documentation, without obtaining and verifying the actual documents, is a significant regulatory and ethical failure. This bypasses critical verification steps mandated by underwriting standards and potentially violates Kansas statutes requiring accurate and complete loan applications and supporting evidence, exposes the borrower to the risk of taking on debt they cannot afford and the lender to increased default risk. Another unacceptable approach is to expedite the approval by overlooking minor discrepancies in the borrower's financial information, such as a slight inconsistency in employment dates or a small difference in reported income. While seemingly minor, these discrepancies can be indicators of larger issues or misrepresentations. Failing to investigate and resolve them constitutes a breach of due diligence and a disregard for the integrity of the underwriting process, potentially violating Kansas regulations that require accurate representation of borrower qualifications. Finally, submitting the loan for approval with incomplete documentation and intending to fix it later is a clear violation of underwriting protocols and regulatory requirements. This practice creates a false impression of loan readiness, undermines the integrity of the lender's risk assessment, and is ethically unsound. It demonstrates a lack of professionalism and a disregard for the legal framework governing loan origination in Kansas. Professionals should employ a decision-making framework that prioritizes compliance and due diligence. This involves understanding the specific underwriting guidelines for the loan product, being intimately familiar with Kansas lending laws and regulations, and maintaining open and transparent communication with borrowers about documentation requirements and timelines. When faced with pressure to expedite, the professional should always default to the established procedures and regulatory mandates, seeking guidance from supervisors or compliance officers if uncertainty arises. Question 3. Consider a scenario where a prospective borrower in Kansas contacts a mortgage loan originator, MLO, and provides basic information about their income, employment, and the property they wish to purchase, indicating their intent to apply for a mortgage. What is the most compliant and ethically sound immediate next step for the MLO? Option A. Verbally commit to a specific interest rate and loan terms to reassure the applicant while awaiting further documentation. Option B. Issue the applicant a loan estimate within 3 business days of receiving the initial application information. Option C. Delay providing any formal disclosures until the applicant submits all supporting documentation, such as pay stubs and bank statements. Option D. Provide the applicant with a general list of potential closing costs, without itemizing them on a formal disclosure document. The correct answer is B. Issue the applicant a loan estimate within 3 business days of receiving the initial application information. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a mortgage loan originator, MLO, in Kansas to navigate the critical initial stage of the mortgage application process, while adhering strictly to Kansas-specific regulations and federal guidelines. The challenge lies in balancing the applicant's immediate need for information and a sense of progress with the legal and ethical obligations to provide accurate disclosures and avoid making premature commitments. Missteps can lead to regulatory violations, applicant dissatisfaction, and potential legal repercussions. Correct approach analysis. The best professional approach involves immediately providing the applicant with the loan estimate, within the federally mandated 3 business day timeframe after receiving the initial application information. This approach is correct because Kansas, like all states, is subject to the Federal Truth in Lending Act (TILA), as implemented by Regulation Z, which mandates the disclosure. The law is designed to provide borrowers with standardized, comparable information about loan terms, estimated settlement costs, and other disclosures necessary for them to make informed decisions. Providing this disclosure promptly is a fundamental regulatory requirement and an ethical imperative to ensure transparency and consumer protection. Incorrect approaches analysis. One incorrect approach is to delay providing the loan estimate until after the applicant has provided additional documentation, such as pay stubs and bank statements. This is a regulatory failure because Regulation Z clearly defines what constitutes an application for the purpose of triggering the disclosure requirement, and it does not require the submission of all supporting documentation before the is due. Delaying this disclosure deprives the applicant of crucial information needed for comparison shopping and decision-making, violating the spirit and letter of consumer protection laws. Another incorrect approach is to verbally commit to a specific interest rate and loan terms before the loan estimate has been issued and the applicant has had an opportunity to review it. This is problematic because verbal commitments can be misleading and may not reflect the final terms once all disclosures are made and underwriting is complete. Furthermore, making such commitments before issuing the can create a false impression of certainty and may violate disclosure requirements if the final terms differ significantly. It also bypasses the standardized disclosure format intended to prevent such premature and potentially inaccurate representations. A third incorrect approach is to only provide a generic list of potential fees without itemizing them on the loan estimate. The loan estimate requires specific itemization of estimated closing costs. Providing only a generic list fails to meet the detailed disclosure requirements of Regulation Z, which aims to give borrowers a clear understanding of all anticipated expenses. This lack of specificity hinders the applicant's ability to compare offers from different lenders and understand the true cost of the loan. Professional reasoning. Professionals in Kansas should adopt a proactive and compliance-focused approach. Upon receiving the initial information that constitutes a loan application, the immediate priority should be to gather the necessary data to accurately complete and issue the loan estimate within the 3 business day window. This involves understanding the definition of an application under Regulation Z and ensuring all required disclosures are provided promptly and accurately. Professionals should maintain clear communication with the applicant, explaining the purpose of the loan estimate and the next steps in the process, while managing expectations regarding final loan terms. A robust internal process for tracking disclosure delivery dates and ensuring accuracy is essential to avoid regulatory violations and maintain client trust. Question 4. Upon reviewing a listing agreement for a standard single-family home in Overland Park, Kansas, a licensee is tasked with providing the seller with an estimated market value. Considering the property is in a well-established neighborhood with numerous recent sales of similar homes, which valuation method would best serve the seller's interests and adhere to professional standards? Option A. Comparative market analysis that examines recent sales of similar properties in the immediate vicinity. Option B. A hybrid approach combining elements of all three methods without prioritizing specific data. Option C. The income approach, focusing on potential rental income the property could generate. Option D. The cost approach, estimating the replacement cost of the home less depreciation. The correct answer is A. A comparative market analysis that examines recent sales of similar properties in the immediate vicinity. Explanation. This scenario presents a professional challenge because a real estate licensee in Kansas must accurately and ethically advise a seller on the value of their property. Misrepresenting value, whether intentionally or through the use of an inappropriate method, can lead to significant financial harm for the seller and potential legal repercussions for the licensee. The challenge lies in selecting the most appropriate valuation method given the specific characteristics of the property and its market, and then communicating that valuation effectively and ethically. The most appropriate approach in this situation is the comparative market analysis. This method is best suited for residential properties in active markets because it directly compares the subject property to similar recently sold properties in the same neighborhood. This approach is grounded in the principle of substitution, where a buyer will not pay more for a property than they would for a comparable substitute. Kansas real estate licensees are ethically bound by the Kansas Real Estate License Act and the National Association of Realtors Registered Code of Ethics, if applicable, to provide competent and diligent service, which includes using valuation methods that are relevant and reliable for the specific property type and market conditions. A CMA aligns with these principles by offering a realistic estimate of market value based on current sales data. Using the income approach would be inappropriate and potentially misleading for a single-family residence that is not primarily an investment property. This approach focuses on the income-generating potential of a property, which is not the primary driver of value for most owner-occupied homes. Relying on this method would fail to reflect the true market dynamics influencing a residential sale and could lead to an inaccurate valuation, violating the duty of competence. The cost approach, which estimates the cost to replace or reproduce the property minus depreciation, is generally most applicable to unique properties, new construction, or properties where comparable sales are scarce. For a typical, established single-family home in a developed neighborhood in Kansas, this method is often less reliable than a CMA because it doesn't directly reflect what buyers are currently willing to pay for similar homes. Its application here would ignore the most direct indicators of market value, potentially leading to an inflated or deflated price, and a failure to meet the standard of care expected of a licensee. Professionals should approach property valuation by first understanding the property type and its primary use. For residential properties, a comparative market analysis is typically the most relevant and reliable tool. If the property has unique characteristics or is an investment property, then consideration of the income or cost approach might be warranted, but always with an understanding of their limitations and applicability. The licensee's duty is to provide an informed opinion of value based on the most appropriate and current data available, ensuring transparency and accuracy for the client. Question. Upon reviewing a listing agreement for a standard single-family home in Overland Park, Kansas, a licensee is tasked with providing the seller with an estimated market value. Considering the property is in a well-established neighborhood with numerous recent sales of similar homes, which valuation method would best serve the seller's interests and adhere to professional standards? Options. A comparative market analysis that examines recent sales of similar properties in the immediate vicinity. B. The income approach, focusing on potential rental income the property could generate. C. The cost approach, estimating the replacement cost of the home less depreciation. D. A hybrid approach combining elements of all three methods without prioritizing specific data. Question 5. When evaluating a property listing in Kansas where the current owners, a brother and sister, state they inherited the property from their parents and have been living there for many years, what is the most critical step a real estate licensee must take to accurately determine the form of ownership before proceeding with a sale? Option A. Assume the property is held as joint tenancy with right of survivorship due to the familial relationship and shared residency. Option B. Proceed with marketing the property based on the assumption that their familial relationship implies a clear and undivided ownership interest. Option C. Accept the owner's verbal explanation of inheritance and long-term residency as sufficient evidence of their ownership rights. Option D. Obtain and meticulously review the property's deed and any other relevant title documents to ascertain the exact legal description and how title is held. The correct answer is D. Obtain and meticulously review the property's deed and any other relevant title documents to ascertain the exact legal description and how title is held. Explanation. Scenario analysis. This scenario presents a common challenge in real estate transactions where a property is held by multiple individuals. The challenge lies in accurately identifying the form of ownership and understanding the implications for transferability and inheritance, which directly impacts the legal and financial security of all parties involved. Misinterpreting ownership can lead to disputes, title defects, and failed transactions, requiring careful due diligence by the licensee. Correct approach analysis. The best approach involves a thorough review of the existing deed and title records to definitively determine the form of ownership. This approach is correct because Kansas real estate law, specifically as it pertains to property transfers and title examination, mandates that the official documentation dictates the nature of ownership. Understanding whether the property is held as fee simple, leasehold, joint tenancy, or tenancy in common is crucial for advising clients on the legal rights and responsibilities associated with each. For instance, joint tenancy with right of survivorship in Kansas allows for automatic transfer to the surviving joint tenant, S, upon death, while tenancy in common does not, requiring probate. A licensee's duty of care under Kansas real estate regulations requires them to ensure all parties understand the implications of the ownership structure before proceeding with any transaction. Incorrect approach is analysis. Relying solely on the verbal statements of the current owners about how they think they own the property is an incorrect approach. This fails to meet the standard of care required by Kansas real estate licensing laws, which emphasize due diligence and verification of facts through official records. Verbal assurances are not legally binding and can be inaccurate or incomplete. Assuming ownership based on the length of time individuals have lived on the property or their familial relationship is also incorrect. These factors do not legally establish ownership type under Kansas law. Furthermore, proceeding with a transaction without a clear understanding of the title, based on assumptions rather than verified documentation, violates the principle of good faith and fair dealing expected of licensed real estate professionals in Kansas. Professional reasoning. Professionals should always prioritize verification of critical information through official documentation. When dealing with property ownership, this means examining the deed, title insurance policies, and any other relevant legal instruments. If ambiguities exist, seeking clarification from legal counsel or a title company is essential. A systematic approach involving document review, client consultation, and if necessary, professional legal advice ensures compliance with Kansas real estate regulations and ethical obligations to protect client interests. Question 6. The analysis reveals that a real estate licensee in Kansas is working with a prospective buyer who explicitly states they do not want to live in a neighborhood with a significant population of a particular ethnic group. The buyer asks the licensee to only show them properties in areas without this ethnic group. What is the most appropriate and legally compliant course of action for the licensee? Option A. Agree to the buyer's request and only show properties in neighborhoods that exclude the specified ethnic group, as the client's preference is paramount. Option B. Politely refuse the buyer's request. Explain that steering clients based on ethnicity is illegal under the Kansas Act Against Discrimination and Federal Fair Housing Act, and offer to show properties in any area that meets the buyer's non-discriminatory criteria. Option C. Inform the buyer that while they cannot directly discriminate, they can avoid showing properties in certain neighborhoods if they believe it would be a bad fit for the buyer, without further explanation. Option D. Subtly guide the buyer towards neighborhoods that align with their stated ethnic preference, without explicitly mentioning the ethnicity, by highlighting other desirable features of those areas. The correct answer is B. Politely refuse the buyer's request. Explain that steering clients based on ethnicity is illegal under the Kansas Act Against Discrimination and Federal Fair Housing Act, and offer to show properties in any area that meets the buyer's non-discriminatory criteria. Explanation. The analysis reveals a scenario that is professionally challenging due to the inherent conflict between a client's stated preference and the legal obligations of a real estate licensee under Kansas fair housing laws. The licensee must navigate the client's discriminatory request while upholding their duty to comply with federal and state anti-discrimination statutes. Careful judgment is required to avoid both violating the law and alienating the client, though legal compliance must always take precedence. The best professional approach involves politely but firmly refusing to act on the discriminatory request and educating the client about their legal obligations under the Kansas Act Against Discrimination and Federal Fair Housing Act. This approach directly addresses the illegal nature of the request, prioritizes legal compliance, and demonstrates ethical conduct. By explaining that steering clients based on protected characteristics is unlawful, the licensee upholds their professional responsibility and educates the client, thereby preventing potential future violations. An incorrect approach involves attempting to subtly steer the client towards or away from certain neighborhoods based on their stated preference, even if done indirectly. This constitutes a violation of the Fair Housing Act and the Kansas Act Against Discrimination, as it facilitates discrimination based on protected classes. Another incorrect approach is to directly refuse to show properties in certain areas without explaining the legal basis for the refusal. While the refusal itself might be legally sound, the lack of education leaves the client uninformed and the licensee open to accusations of arbitrary discrimination or bias. Furthermore, agreeing to the client's request and proceeding with the discriminatory steering is a clear and egregious violation of both federal and state fair housing laws, exposing the licensee and their brokerage to significant legal penalties and professional sanctions. Professionals should employ a decision-making framework that begins with identifying the core legal and ethical obligations. When faced with a client request that conflicts with these obligations, the immediate step is to consult the relevant statutes. In this case, the Kansas Act Against Discrimination and the Federal Fair Housing Act. The next step is to communicate clearly and professionally with the client, explaining the legal prohibitions and the licensee's inability to comply with discriminatory requests. This communication should be educational, aiming to foster understanding of fair housing principles. If the client persists with discriminatory requests, the licensee must consider whether they can continue to represent the client ethically and legally. Question 7. The risk matrix shows a potential client in Kansas is interested in diversifying their investment portfolio and has specifically inquired about the benefits and risks associated with real estate investment trusts, REIT. As a licensed real estate salesperson in Kansas, how should you best address this inquiry? Option A. Recommend a specific REIT that you have researched and believe offers good potential returns, based on your understanding of real estate markets. Option B. Advise the client that REIT are too complex and risky for individual investors and suggest they focus solely on traditional real estate transactions. Option C. Inform the client that as a licensed real estate salesperson, you are not qualified to provide investment advice on securities like REIT and recommend they consult with a licensed financial advisor or securities professional. Option D. Provide a general overview of what REIT are, discussing their potential tax advantages and historical performance, without making specific recommendations. The correct answer is C. Inform the client that as a licensed real estate salesperson, you are not qualified to provide investment advice on securities like REIT and recommend they consult with a licensed financial advisor or securities professional. Explanation. This scenario is professionally challenging because it requires a real estate salesperson in Kansas to navigate the complexities of advising a client on an investment vehicle that, while related to real estate, operates under securities regulations. The salesperson must understand the boundaries of their license and avoid providing advice that falls outside their expertise and regulatory authority, which could lead to legal and ethical repercussions. The correct approach involves recognizing that a real estate investment trust REIT is a security and that advising on its suitability as an investment falls under securities law, not Kansas real estate licensing law. Therefore, the salesperson should clearly inform the client that they are not licensed to provide investment advice on securities and recommend consulting with a qualified financial advisor or securities professional who holds the appropriate licenses. This aligns with Kansas real estate regulations that prohibit licensed individuals from engaging in activities for which they are not licensed, and ethical obligations to act in the client's best interest by not overstepping professional boundaries. An incorrect approach would be to provide a general overview of rate, discussing their tax advantages and potential returns, without explicitly stating the limitations of their licensing. This is problematic because it could be construed as providing investment advice, even if not explicitly recommending a specific rate. It blurs the line between general information and specific investment guidance, potentially misleading the client into believing the salesperson is qualified to offer such advice. This could violate Kansas real estate regulations regarding unlicensed activity and ethical duties. Another incorrect approach would be to recommend a specific rate based on personal research or anecdotal evidence. This is a direct violation of securities regulations and Kansas real estate licensing laws. The salesperson is not licensed to recommend securities, and doing so constitutes practicing as a securities broker or investment advisor without the proper registration and licenses. This exposes both the salesperson and potentially the brokerage to significant legal penalties and reputational damage. Finally, an incorrect approach would be to dismiss the client's interest in rate entirely without offering any guidance on where they might seek appropriate advice. While avoiding providing unlicensed advice is crucial, a professional should still aim to be helpful within their scope. Simply ignoring the client's inquiry, even if motivated by a desire to avoid regulatory issues, can be seen as a failure to act in the client's best interest and a missed opportunity to guide them toward qualified professionals. The professional reasoning process should involve a clear understanding of one's licensing scope. When faced with a client inquiry that touches upon areas outside of real estate brokerage, such as securities or investment advice, the professional should 1. Identify the nature of the inquiry and determine if it falls within their licensed activities. 2. If it does not, clearly and politely inform the client of their limitations. 3. Recommend that the client seek advice from a qualified and licensed professional in the relevant field. 4. Document the interaction and the advice provided to the client. Question 8. Implementation of a real estate transaction in Kansas involves a buyer who is pre-approved for a conventional mortgage, but is also inquiring about the feasibility and benefits of FHA and VA loans. As a licensed Kansas real estate salesperson, what is the most appropriate course of action to assist this buyer regarding their financing inquiries? Option A. Recommend that the buyer proceed with the conventional loan they are pre-approved for, as it is generally simpler and faster to close, and discourage them from exploring FHA or VA loans due to potential complexities. Option B. Advise the buyer that FHA and VA loans are typically only suitable for first-time homebuyers with limited credit and suggest they focus on their conventional loan pre-approval. Option C. Offer to contact mortgage lenders on behalf of the buyer, explain the buyer's financial profile, and negotiate loan terms to secure the most favorable financing for them. Option D. Provide the buyer with general information about the characteristics and typical requirements of conventional, FHA, and VA loans, and strongly advise them to consult with a licensed mortgage lender or broker to determine which loan product best suits their specific financial situation and goals. The correct answer is D. Provide the buyer with general information about the characteristics and typical requirements of conventional, FHA, and VA loans, and strongly advise them to consult with a licensed mortgage lender or broker to determine which loan product best suits their specific financial situation and goals. Explanation. This scenario is professionally challenging because it requires a real estate salesperson in Kansas to navigate the complexities of financing options while prioritizing the client's best interests and adhering to Kansas real estate law. The salesperson must understand the implications of different loan types and their impact on the buyer's financial stability and the transaction's success, without overstepping into providing financial advice. Careful judgment is required to offer relevant information without crossing the line into unlicensed activity. The best approach involves the salesperson acting as an informational conduit, connecting the buyer with qualified professionals, and providing general, factual information about common financing methods available in Kansas. This includes explaining the basic characteristics of conventional loans, FHA loans, VA loans, and USDA loans, and advising the buyer to consult with a mortgage lender or broker to determine the most suitable option based on their individual financial situation. This approach is correct because it aligns with the Kansas Real Estate License Act, which permits licensees to provide general information about financing, but prohibits them from offering specific financial advice or acting as a loan originator. By facilitating access to qualified professionals and offering factual, non-advisory information, the salesperson upholds their fiduciary duty to the client while operating within legal boundaries. An incorrect approach would be for the salesperson to recommend a specific type of loan based on their personal opinion or a perceived benefit to the seller, without fully understanding the buyer's financial capacity or the loan's suitability. This is ethically problematic as it prioritizes the transaction over the buyer's well-being and could lead to a buyer taking on a loan they cannot afford, potentially resulting in default. It also ventures into providing financial advice, which is outside the scope of a real estate license in Kansas and could expose the salesperson to legal liability. Another incorrect approach would be for the salesperson to discourage the buyer from exploring certain loan types, such as FHA or VA loans, because they might perceive these as more complex or time-consuming. This is discriminatory and unethical, as it limits the buyer's options based on the salesperson's convenience rather than the buyer's needs. It also fails to uphold the duty of full disclosure and fair representation. A further incorrect approach would be for the salesperson to offer to help the buyer secure financing by contacting lenders on their behalf and negotiating loan terms. This constitutes unlicensed mortgage brokering activity, which is a serious violation of Kansas law and carries significant penalties. The salesperson's role is to facilitate the real estate transaction, not to act as a financial intermediary. Professionals should employ a decision-making framework that prioritizes client education and access to qualified experts. This involves understanding the scope of their license, identifying situations where specialized advice is needed, and proactively connecting clients with appropriate professionals. When discussing financing, the focus should be on providing general information about available options and empowering the client to make informed decisions with the guidance of financial experts. Question 9. To address the challenge of a known, significant foundation issue discovered during a pre-listing inspection of a property in Wichita, Kansas, which approach should a licensed real estate salesperson recommend to their seller client and communicate to the prospective buyer? Option A. Inform the seller of the issue and suggest they attempt to discreetly repair the foundation before the buyer's final walkthrough, without informing the buyer of the original discovery. Option B. Advise the seller to proceed with the sale, hoping the buyer does not discover the foundation problem during their own inspections or after closing. Option C. Immediately disclose the foundation issue to both the seller and the prospective buyer, advising them to obtain a professional assessment and discuss potential remedies or price adjustments. Option D. Recommend the seller reduce the asking price without explicitly stating the reason for the reduction to the buyer, allowing the buyer to discover the issue independently. The correct answer is C. Immediately disclose the foundation issue to both the seller and the prospective buyer, advising them to obtain a professional assessment and discuss potential remedies or price adjustments. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves a potential conflict of interest and the obligation to disclose material facts to all parties involved in a real estate transaction. A real estate licensee in Kansas has a fiduciary duty to their client, but also an ethical and legal obligation to be honest and transparent with all parties, even if it means jeopardizing a potential sale or lease. Misrepresenting or withholding material information can lead to legal repercussions, disciplinary action by the Kansas Real Estate Commission, and damage to the licensee's reputation. Correct approach analysis. The best professional practice is to immediately disclose the known foundation issue to both the seller and the prospective buyer. This approach upholds the licensee's fiduciary duty to the seller by acting in their best interest to facilitate an informed transaction, and it also fulfills the ethical and legal obligation to the buyer to provide accurate and complete information about the property's condition. Transparency in this situation, even if it leads to renegotiation or the buyer withdrawing their offer, is paramount. Kansas real estate law emphasizes honesty and fair dealing, and withholding such a significant defect would violate these principles. Incorrect approaches analysis. Failing to disclose the foundation issue to the buyer, while informing the seller to potentially fix it quietly before closing, is a significant ethical and legal failure. This misleads the buyer about the property's true condition, violating the duty of honesty and fair dealing required by Kansas law. It also potentially exposes the seller to liability if the issue is discovered later. suggesting to the seller that they hope the buyer doesn't notice, and proceeding with the transaction without disclosure is a direct violation of the licensee's duty to both parties. This approach is dishonest and unethical, and it exposes all parties, including the licensee, to potential legal action and disciplinary sanctions from the Kansas Real Estate Commission. Advising the seller to simply reduce the price without disclosing the reason for the reduction to the buyer is also problematic. While price adjustments are common, failing to disclose the underlying material defect is deceptive. The buyer has a right to know why the price is being reduced, especially when it's due to a significant issue like a foundation problem. This lack of transparency undermines the integrity of the transaction. Professional reasoning. Professionals in Kansas should always prioritize honesty, transparency, and adherence to the Kansas Real Estate License Act. When faced with a situation involving a material defect, the decision-making process should involve 1. Identifying the material fact, the foundation issue. 2. Recognizing the fiduciary duty to the client seller and the duty of honesty and fair dealing to all parties buyer. 3. Consulting relevant Kansas real estate laws and regulations regarding disclosure. 4. Communicating openly and honestly with all parties involved, recommending professional inspection and disclosure of the defect. 5. Documenting all communications and actions taken. Question 10. Examination of the data shows that a Kansas real estate salesperson, working under a licensed broker, successfully facilitated the sale of a property listed at $350,000. The listing agreement stipulated a total commission of 6% of the sale price. The buyer was represented by a different brokerage, and the co-brokerage agreement between the listing broker and the buyer's broker stipulated a 50/50 split of the total commission. The salesperson's personal commission split with their employing broker is 70% of the commission earned by their brokerage. Assuming the sale closed and all funds are available, what is the salesperson's net commission in dollars? Option A, $6, 125. Option B, $7, 350. Option C, $5, 250. Option D, $10, 500. The correct answer is B, $7, 350. Explanation. Scenario analysis. This scenario presents a common challenge in real estate transaction where a salesperson must accurately calculate commission splits based on a complex agreement. Miscalculations can lead to disputes with the employing broker, potential financial losses for the salesperson, and damage to professional relationships. Adherence to the Kansas Real Estate License Act and established brokerage agreements is paramount to ensure fair and legal distribution of funds. Correct approach analysis. The best approach involves meticulously reviewing the listing agreement and the buyer's agency agreement to identify the total commission percentage and any agreed-upon referral fees or co-brokerage arrangements. Subsequently, the salesperson must apply the agreed-upon split percentage between the listing broker and the buyer's broker, and then apply their individual split percentage with their employing broker. This systematic calculation ensures that all parties receive their contractually obligated share of the commission, aligning with the principles of transparency and contractual integrity mandated by the Kansas Real Estate License Act. Incorrect approaches analysis. One incorrect approach is to simply divide the total commission by 2 and then apply the salesperson's personal split, ignoring the specific terms of the listing agreement and the buyer's agency agreement. This fails to account for potential co-brokerage fees or different commission rates negotiated in each agreement, violating the contractual obligations to all parties involved and potentially breaching the Kansas Real Estate License Act's requirements for honest dealing. Another incorrect approach is to calculate the commission based solely on the salesperson's personal understanding of typical splits, without referring to the executed agreements. This introduces a high risk of error and disregards the legally binding nature of the contracts. Such an action could be considered a violation of the salesperson's fiduciary duty to their client and their employing broker, and could lead to disciplinary action under the Kansas Real Estate License Act. A third incorrect approach is to estimate the commission split based on a quick mental calculation without documenting the steps. This method is prone to arithmetic errors and lacks the transparency required in financial transactions. It also fails to provide a clear audit trail if a dispute arises, potentially leading to legal complications and a violation of professional standards of practice. Professional reasoning. Professionals should always prioritize accuracy and transparency in financial matters. This involves a disciplined approach. First, thoroughly understand the terms of all relevant agreements. Second, perform calculations methodically, documenting each step. Third, cross-reference the results. And finally, communicate clearly with all parties involved regarding commission distribution. When in doubt, consulting with the employing broker or seeking clarification on contractual terms is essential to uphold ethical and legal standards. Question 11. Research into a property listing in rural Kansas reveals a substantial acreage with a well-maintained farmhouse, several barns, and extensive cultivated fields. The owner mentions they occasionally sell surplus produced directly to consumers from a small, informal stand near the road. Considering the predominant features and intended use, what is the most accurate classification of this property for listing and marketing purposes under Kansas real estate guidelines? Option A, commercial property due to the occasional sale of produce. Option B, residential property as it contains a dwelling. Option C, mixed-use property, reflecting both residential and commercial activities. Option D, agricultural property, with the farmhouse serving as a primary residence for the farm operator. The correct answer is D, agricultural property, with the farmhouse serving as a primary residence for the farm operator. Explanation. This scenario presents a professional challenge because a real estate licensee must accurately identify the primary classification of a property to ensure they are operating within their expertise and adhering to Kansas real estate regulations. Misclassifying a property can lead to misrepresentation, failure to disclose critical information relevant to that property type, and potential violations of Kansas license law, which mandates that licensees act with honesty and integrity. Careful judgment is required to distinguish between property types based on their predominant use and characteristics. The best professional approach involves a thorough assessment of the property's primary function and intended use, supported by observable characteristics and any available documentation. This includes understanding the defining features of residential, commercial, industrial, and agricultural properties as recognized under Kansas real estate practices. For instance, a property primarily used for dwelling purposes, regardless of its size or potential for ancillary activities, would be classified as residential. This approach ensures compliance with Kansas real estate laws by promoting accurate representation and informed client service, preventing potential legal and ethical breaches. An incorrect approach would be to classify the property based solely on a secondary or potential use without considering its dominant characteristic. For example, labeling a large rural property with a single-family home as commercial simply because the owner occasionally sells produce from a small roadside stand would be a misclassification. This fails to acknowledge the primary residential nature of the dwelling and the agricultural use of the land, potentially leading to the licensee providing advice or marketing strategies inappropriate for the property's core classification. This could violate Kansas regulations requiring licensees to have sufficient knowledge of the property type they are representing. Another incorrect approach is to rely on the owner's subjective opinion or a previous, potentially outdated, classification without independent verification. If the owner states the property has always been considered mixed use, without clear evidence of distinct commercial or industrial operations alongside residential use, the licensee has a duty to investigate further. Failing to do so could result in misrepresentation if the property's actual use or zoning does not support such a broad classification under Kansas law. A professional decision-making framework for similar situations involves a systematic evaluation process. 1. Identify the property's primary physical characteristics and intended use. 2. Consult relevant zoning ordinances and local regulations in Kansas. 3. Review any existing documentation, e.g., deeds, permits for clues to its classification. 4. If ambiguity exists, seek clarification from relevant authorities or consult with experienced professionals specializing in the suspected property type. 5. Prioritize accuracy and transparency in all representations to clients and the public. Question 12. Which approach would be most effective for a licensed real estate salesperson in Kansas when explaining the definition and importance of real estate to a prospective buyer who has limited prior knowledge of property transactions? Option A. Emphasize the speculative investment opportunities and potential for rapid appreciation in value, downplaying the physical attributes of the property. Option B. Focus exclusively on the physical characteristics of the land and any buildings, without discussing its potential as an investment or its broader economic role. Option C. Define real estate as the physical land and all permanent structures attached to it, while also highlighting its significance as a tangible asset, a potential investment, and a key element of the economy in Kansas. Option D. Use complex legal terminology to describe real estate, such as corporeal hereditaments, without further elaboration on their practical meaning for a buyer. Correct answer is C. Define real estate as the physical land and all permanent structures attached to it, while also highlighting its significance as a tangible asset, a potential investment, and a key element of the economy in Kansas. Explanation. This scenario presents a professional challenge because a real estate licensee must accurately represent the value and nature of a property to potential buyers, adhering to both ethical standards and Kansas real estate law. Misrepresenting the definition and importance of real estate can lead to significant legal and ethical repercussions, including license suspension or revocation, and financial damages to clients. Careful judgment is required to ensure all statements are truthful, not misleading, and align with the established understanding of real estate as both tangible property and an investment. The best approach involves clearly defining real estate as the physical land and any permanent improvements upon it, while also emphasizing its importance as a tangible asset, a potential investment, and a fundamental component of economic activity within Kansas. This approach is correct because it aligns with the fundamental definition of real estate as understood in property law and real estate practice, and it fulfills the licensee's ethical obligation under the Kansas Real Estate License Act to be honest and truthful in all dealings. By highlighting both the physical and economic aspects, the licensee provides a comprehensive and accurate understanding, avoiding any misrepresentation or omission that could mislead a buyer. An approach that focuses solely on the physical aspects of real estate, neglecting its investment potential or economic significance, is professionally unacceptable. This is because it fails to provide a complete picture of what real estate represents to a buyer, potentially leading them to underestimate its value or overlook crucial investment considerations. Such an omission could be considered misleading under Kansas real estate regulations, which require licensees to act with integrity. Another professionally unacceptable approach is to overemphasize speculative investment potential without grounding it in the tangible realities of the property and market conditions. This can lead to unrealistic expectations and potential financial harm to buyers, violating the duty of care and honesty owed to clients under Kansas law. It also risks misrepresenting the true nature and importance of the real estate itself. Finally, an approach that defines real estate in overly technical legal jargon without explaining its practical implications for a buyer is also problematic. While legally accurate, it fails to effectively communicate the importance and definition of real estate to a layperson, potentially leaving them uninformed and unable to make sound decisions. This falls short of the ethical requirement to communicate clearly and effectively with clients. Professionals should employ a decision-making framework that prioritizes clarity, accuracy, and completeness when defining and discussing real estate. This involves understanding the legal definition, the practical implications for buyers and sellers, and the ethical obligations to be truthful and avoid misrepresentation. Always consider the audience and tailor the explanation to ensure comprehension, while remaining within the bounds of legal and ethical conduct, as prescribed by Kansas statutes and regulations. Question 13. Operational review demonstrates that a tenant in a Kansas property, currently under a one-year lease agreement, has requested several modifications to the terms of their occupancy, including permission to paint a specific room and to install a small garden. As a licensed real estate salesperson in Kansas, what is the most appropriate course of action to advise the tenant? Option A. Advise the tenant to submit all proposed changes in writing to the landlord for review and formal agreement. Option B. Advise the tenant to make the desired changes directly to a printed copy of the lease agreement before signing. Option C. Advise the tenant to verbally discuss and agree to the changes with the landlord, as verbal agreements are often sufficient. Option D. Advise the tenant that lease agreements are standard documents and cannot be altered once they are in effect. The correct answer is A. Advise the tenant to submit all proposed changes in writing to the landlord for review and formal agreement. Explanation. Scenario analysis. This scenario presents a common challenge for real estate licensees in Kansas, navigating the nuances of lease agreements when a tenant requests modifications. A professional challenge lies in balancing the tenant's desire for customization with the legal requirements and best practices for lease documentation, ensuring enforceability and protecting both parties' interests. Missteps can lead to disputes, legal liabilities, and damage to the licensee's reputation. Correct approach analysis. The best professional practice involves advising the tenant to submit all proposed changes in writing. This approach is correct because Kansas law, while not dictating specific lease modification procedures, emphasizes clear communication and written documentation for contractual agreements. A written addendum, signed by both landlord and tenant, serves as legally binding evidence of the agreed-upon terms, preventing misunderstandings and providing a clear record. This aligns with the principle of good faith and fair dealing expected of licensed professionals. Incorrect approaches analysis. Advising the tenant to verbally agree to the changes with the landlord is professionally unacceptable. Verbal agreements, while sometimes legally binding for certain contracts, are notoriously difficult to prove and are prone to misinterpretation or outright denial. This approach fails to create a clear, enforceable record, potentially leading to disputes over the terms of the lease. It also exposes the licensee to liability if the landlord later denies the verbal agreement. Suggesting the tenant make the changes directly to a printed lease agreement without formal amendment is also professionally unacceptable. Unauthorized alterations to a legal document can render it invalid or create significant legal complications. This bypasses the necessary steps of mutual agreement and proper documentation, undermining the integrity of the contract and potentially exposing both parties to legal risks. Telling the tenant that lease agreements are non-negotiable and cannot be altered after signing is professionally unacceptable and factually incorrect. Lease agreements, like most contracts, can be amended by mutual consent of the parties involved. While standard forms exist, landlords and tenants are generally free to negotiate and agree upon modifications, provided these are properly documented. This approach demonstrates a lack of understanding of contract law and tenant rights. Professional reasoning. Professionals in Kansas should adopt a decision-making process that prioritizes clear, written communication and adherence to contractual formalities. When a tenant requests lease modifications, the licensee's role is to facilitate a process that ensures all changes are documented and agreed upon by all parties. This involves advising the tenant to submit requests in writing, and then working with the landlord and tenant to create a formal addendum or amendment to the lease, signed by all parties. This systematic approach minimizes risk and upholds professional standards. Question 14. Quality control measures reveal that a Kansas real estate licensee, when discussing financing options with a prospective buyer, primarily emphasized the lower initial monthly payments associated with both adjustable rate and interest-only mortgages, without fully detailing the long-term implications and risks of each. Which of the following approaches best reflects the ethical and regulatory obligations of the licensee in Kansas? Option A. Strongly recommend an adjustable rate mortgage due to its typically lower initial interest rate, assuring the client that rates are unlikely to rise significantly in the near future. Option B. Focus exclusively on the interest-only mortgage option, highlighting its significantly lower monthly payments as the primary advantage for immediate affordability. Option C. Clearly explain the fundamental differences between fixed-rate, adjustable rate, and interest-only mortgages, detailing the potential benefits and risks of each in the context of the client's stated financial situation and future plans. Option D. Present all mortgage types as equally beneficial, allowing the client to choose based solely on their initial preference for monthly payment amounts. The correct answer is C. Clearly explain the fundamental differences between fixed-rate, adjustable rate, and interest-only mortgages, detailing the potential benefits and risks of each in the context of the client's stated financial situation and future plans. Explanation. Scenario analysis. This scenario presents a professional challenge because a real estate licensee must balance the client's immediate financial concerns with the long-term implications of mortgage choices. Misrepresenting or failing to fully explain mortgage types can lead to significant financial harm for the client and potential legal repercussions for the licensee. The challenge lies in providing accurate, unbiased information that empowers the client to make an informed decision aligned with their financial goals and risk tolerance, all within the regulatory framework of Kansas real estate law. Correct approach analysis. The best professional approach involves clearly and accurately explaining the fundamental differences between fixed rate, adjustable rate, and interest-only mortgages, highlighting the potential benefits and risks of each in the context of the client's stated financial situation and future plans. This includes explaining how interest rates behave in fixed-rate mortgages, how they fluctuate in adjustable-rate mortgages, and the potential impact on monthly payments, and the principal repayment structure of interest-only loans. This approach is correct because Kansas real estate licensees have a fiduciary duty to act in the best interest of their clients, which includes providing complete and truthful information about all relevant aspects of a transaction, including financing options. This aligns with the Kansas real estate license Act's emphasis on honesty, integrity, and avoiding misrepresentation. Incorrect approaches analysis. One incorrect approach involves focusing solely on the initial lower monthly payment of an adjustable-rate mortgage without adequately explaining the risk of future payment increases due to interest rate fluctuations. This is ethically problematic as it omits crucial information about potential long-term financial strain and violates the duty of full disclosure. Another incorrect approach is to strongly advocate for an interest-only mortgage simply because it offers the lowest initial payment, without thoroughly discussing the fact that the principal balance does not decrease during the interest-only period, and that the client will still owe the full loan amount at the end of that term. This misleads the client into believing they are building equity faster than they actually are, and fails to address the significant repayment challenge at the end of the interest-only period, potentially violating Kansas regulations against deceptive practices. A third incorrect approach is to present all mortgage types as equally viable, without probing the client's financial stability, long-term housing plans, or risk tolerance, thereby failing to provide tailored advice and potentially leading the client to a product unsuitable for their circumstances. This neglects the licensee's responsibility to facilitate a transaction that is in the client's best interest. Professional reasoning. Professionals should approach client consultations by first understanding the client's financial situation, goals, and risk tolerance. This involves active listening and asking probing questions. Subsequently, all relevant options should be presented factually and neutrally, with a clear explanation of the pros and cons of each, tailored to the client's specific circumstances. The licensee's role is to educate and guide, not to pressure or misrepresent. Adherence to the Kansas Real Estate License Act's principles of honesty, integrity, and full disclosure is paramount. Question 15. The assessment process reveals a Kansas real estate agent is assisting a client who wishes to purchase a home using a VA loan. The agent has previously handled conventional loans, but has limited experience with government-backed programs. The client is eager to close quickly. What is the most prudent course of action for the agent to ensure a successful transaction while adhering to Kansas regulations? Option A. Advise the client that VA loans are generally straightforward and that the closing timeline will likely be similar to conventional loans, without detailing specific program nuances. Option B. Proceed with the transaction using the same general process as a conventional loan, assuming the VA loan will be approved without significant deviation. Option C. Focus solely on securing the best interest rate for the client, assuming the VA loan's specific property and eligibility requirements will be handled by the lender without the agent's direct involvement. Option D. Thoroughly research the specific property eligibility requirements and appraisal standards for VA loans, and clearly communicate these to the client, including any potential timelines or repair obligations that may differ from conventional loans. The correct answer is D. Thoroughly research the specific property eligibility requirements and appraisal standards for VA loans, and clearly communicate these to the client, including any potential timelines or repair obligations that may differ from conventional loans. Explanation. The assessment process reveals a common implementation challenge when working with government-backed loans in Kansas, ensuring that all parties understand and adhere to the specific eligibility and disclosure requirements for FHA, VA, and USDA loans. This scenario is professionally challenging because misinterpreting or failing to communicate these nuances can lead to significant delays, borrower disappointment, and potential regulatory violations. Careful judgment is required to navigate the distinct criteria of each program and to provide accurate guidance to clients. The best professional approach involves proactively educating the borrower about the specific requirements of their chosen government-backed loan program, including any unique property standards or borrower eligibility nuances. This includes clearly explaining the appraisal process, potential repair obligations, and the timeline associated with FHA, VA, or USDA approvals. This approach is correct because it aligns with the Kansas Real Estate License Act's emphasis on honesty, fairness, and competence, ensuring that clients are fully informed and can make sound decisions. It also preempts potential issues by addressing program-specific requirements upfront, thereby fostering trust and facilitating a smoother transaction. An incorrect approach involves assuming that the general mortgage lending process is sufficient for government-backed loans without delving into program-specific details. This failure to recognize the distinct appraisal standards and eligibility criteria for FHA, VA, and USDA loans can lead to the borrower being unprepared for unexpected property condition requirements or loan denials, violating the duty of competence. Another incorrect approach is to provide vague assurances about loan approval without thoroughly verifying the borrower's eligibility and the property's compliance with the specific program guidelines. This can mislead the borrower and create unrealistic expectations, potentially violating ethical obligations to be truthful and transparent. A further incorrect approach is to delay informing the borrower about potential program-specific challenges, such as the need for specific repairs mandated by an FHA appraisal, until late in the process. This lack of timely communication can cause significant stress and financial implications for the borrower, demonstrating a failure to act in the client's best interest and potentially violating disclosure requirements. Professionals should employ a decision-making framework that prioritizes thorough research into the specific requirements of each government-backed loan program. This involves consulting official program guidelines, engaging with experienced loan officers specializing in these products, and maintaining open and continuous communication with the borrower. A commitment to ongoing education and a client-centric approach are paramount to successfully navigating the complexities of FHA, VA, and USDA loans in Kansas. Question 16. Cost-benefit analysis shows that while both hard money loans and seller financing offer alternative avenues for real estate investment in Kansas, they present distinct risk profiles and operational considerations. A real estate salesperson is asked by a client to explain the advantages and disadvantages of each. Which approach best serves the client's interest and adheres to Kansas real estate licensing regulations? Option A. Advocate for seller financing as the simplest and most flexible option, focusing on the potential for negotiation while downplaying the necessity for independent legal review of the financing agreement. Option B. Strongly recommend hard money loans as the most efficient financing method for investors in Kansas due to their rapid funding times, without extensively detailing the associated higher interest rates and shorter repayment terms. Option C. Clearly explain the typical characteristics, common terms, and inherent risks associated with both hard money loans and seller financing, emphasizing the importance of the client consulting with independent financial and legal professionals for personalized advice. Option D. Advise the client to select a specific hard money lender or a particular seller financing structure based on the salesperson's personal experience, without ensuring the salesperson holds the appropriate lending or advisory licenses. The correct answer is C. Clearly explain the typical characteristics, common terms, and inherent risks associated with both hard money loans and seller financing, emphasizing the importance of the client consulting with independent financial and legal professionals for personalized advice. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate salesperson in Kansas to advise a client on financing options that carry significant risk and have complex implications. The salesperson must navigate the nuances of hard money loans and seller financing, understanding their respective benefits and drawbacks, without providing unlicensed financial advice. The core challenge lies in educating the client about these options within the scope of their real estate license, ensuring transparency, and avoiding any misrepresentation or steering that could lead to financial harm or regulatory violations under Kansas real estate law. Correct approach analysis. The best professional practice involves clearly outlining the characteristics, typical terms, and inherent risks of both hard money loans and seller financing, empowering the client to conduct their own due diligence and consult with qualified financial professionals. This approach educates the client on the nature of these financing methods, such as the higher interest rates and shorter terms of hard money loans, and the potential for negotiation and flexibility in seller financing. It emphasizes that the salesperson's role is to present information about these financing vehicles as they relate to real estate transactions, not to recommend one over the other or to provide financial advice. This aligns with Kansas real estate regulations that prohibit licensees from engaging in activities requiring a securities or mortgage broker license and mandate truthful and non-misleading representations. Incorrect approaches analysis. Presenting hard money loans as a universally superior option due to their speed, without a thorough discussion of their significantly higher costs and shorter repayment periods, is an ethically flawed approach. This could be construed as steering the client towards a potentially detrimental financing choice without adequate disclosure of the associated risks, violating the duty of honesty and fair dealing. Similarly, advocating for seller financing solely based on its perceived simplicity, without detailing the critical need for independent legal counsel to draft and review the agreement, and without acknowledging the potential for the seller to impose unfavorable terms or the buyer to face foreclosure if unable to meet obligations, is also problematic. This fails to adequately protect the client's interests and could lead to significant financial and legal repercussions. Recommending a specific hard money lender or a particular seller financing structure without proper licensing or a comprehensive understanding of the client's complete financial picture constitutes unlicensed activity and a breach of fiduciary duty. Professional reasoning. Professionals should approach such situations by focusing on education and disclosure. The decision-making process should involve 1. Identifying the client's stated needs and goals. 2. Explaining the general characteristics and common risks/benefits of available financing options relevant to real estate transactions in Kansas, such as hard money and seller financing. 3. Clearly delineating the salesperson's role as an information provider and facilitator, not a financial advisor or lender. 4. Strongly advising the client to seek independent professional advice from licensed financial advisors, mortgage brokers, and legal counsel before making any financing decisions. 5. Documenting all discussions and recommendations made to the client. Question 17. Cost-benefit analysis shows that a seller in Kansas is concerned about maximizing the exposure of their property to potential buyers, but also expresses a desire to avoid paying a commission if they happen to find the buyer through their own personal network. Considering these objectives and the standard listing agreement types available in Kansas, which approach would best align with the seller's stated goals while upholding professional and regulatory standards for a Kansas real estate licensee? Option A. Recommend a net listing agreement, stating that the seller will receive a predetermined net amount and the broker will earn the difference, without discussing potential conflicts of interest or the broker's incentive to achieve the highest possible sale price. Option B. Recommend an open listing agreement, explaining that multiple brokers can market the property and the seller owes no commission if they find the buyer, but not detailing the potential for inconsistent marketing or lack of dedicated effort. Option C. Recommend an exclusive right to sell listing agreement, emphasizing the broker's commitment to comprehensive marketing and explaining that while a commission is owed if the seller finds the buyer, the broker's extensive marketing efforts significantly increase the overall probability of a sale. Option D. Recommend an exclusive agency listing agreement, highlighting that the seller will not owe a commission if they find the buyer themselves, but acknowledging that the broker's marketing efforts might be less intensive. The correct answer is C. Recommend an exclusive right to sell listing agreement, emphasizing the broker's commitment to comprehensive marketing and explaining that while a commission is owed if the seller finds the buyer, the broker's extensive marketing efforts significantly increase the overall probability of a sale. Explanation. Scenario analysis. This scenario presents a common challenge for real estate licensees in Kansas, advising a seller on the most appropriate type of listing agreement. The seller's desire for maximum exposure versus their concern about paying a commission if they find the buyer themselves creates a conflict that requires careful navigation. A licensee must understand the nuances of each listing agreement type and how they align with both the seller's objectives and Kansas real estate law and ethical standards to provide competent and lawful advice. Correct approach analysis. The approach that best serves the seller's stated goals and aligns with professional practice in Kansas is to recommend an exclusive right to sell listing agreement. This agreement guarantees the listing broker a commission regardless of who procures the buyer, including the seller themselves. While this might seem counterintuitive to the seller's concern about finding their own buyer, it is the most common and generally preferred listing agreement by brokers because it provides the greatest incentive for the broker to invest time, money, and marketing efforts into selling the property. In Kansas, exclusive right to sell agreements are legally recognized and widely used. Ethically, by recommending this, the licensee is prioritizing a comprehensive marketing strategy that maximizes the chances of a sale, while also ensuring the broker is compensated for their significant efforts, which is a fair exchange. The licensee can then explain to the seller how the broker's marketing efforts will increase the likelihood of a sale, even if the seller happens to find a buyer through their own network. Incorrect approaches analysis. Recommending an exclusive agency listing agreement would be a failure to fully address the seller's desire for maximum exposure. While this agreement allows the seller to find a buyer themselves without owing a commission, it significantly reduces the broker's incentive to market the property aggressively, as they only earn a commission if they, or a subagent, find the buyer. This could lead to a less effective marketing campaign and potentially a longer time on the market, which may not align with the seller's ultimate goal of selling. Furthermore, it could create confusion if the seller introduces a potential buyer they found, and the broker then has to determine if their own efforts contributed to that sale, potentially leading to disputes. Suggesting an open listing agreement would be professionally unacceptable and potentially violate Kansas real estate regulations regarding clear agency relationships and compensation. An open listing offers the least protection and incentive for any specific broker. Multiple brokers can market the property, and the seller can sell it themselves without owing a commission to anyone. This fragmented approach often leads to inconsistent marketing, confusion among potential buyers and agents, and a lack of dedicated effort from any single brokerage. It is generally discouraged by professional associations and can be difficult to manage effectively, potentially leading to disputes over who is entitled to a commission if a sale occurs. Recommending a net listing agreement would be highly problematic and is often considered unethical and potentially illegal in many jurisdictions, including implicitly through agency duties in Kansas. A net listing allows the seller to specify a minimum amount they wish to receive from the sale, with the broker earning any amount above that figure. This creates a significant conflict of interest, as the broker's incentive is to sell the property for the highest possible price, not necessarily the price that is best for the seller's overall financial outcome, as the broker's commission is directly tied to the difference between the net price and the sale price. This structure can lead to exploitation of the seller and is not in line with the fiduciary duties owed by a Kansas real estate licensee to their client. Professional reasoning. When advising a seller on listing agreements, a Kansas licensee should first thoroughly understand the seller's primary objectives: maximizing exposure, minimizing risk of paying a commission, and achieving a specific sale price. The licensee must then explain the implications of each type of listing agreement in terms of broker motivation, marketing effort, and commission liability. The licensee's role is to guide the seller towards the agreement that best balances these factors, while ensuring compliance with Kansas real estate license law and ethical standards, prioritizing transparency and the client's best interests within the legal framework. Question 18. Market research demonstrates that a real estate licensee in Kansas has successfully listed a property for sale and is now considering representing a buyer who is interested in purchasing that same property. What is the most appropriate and legally compliant course of action for the licensee to take to manage this potential agency relationship? Option A. Advise the buyer to seek independent representation and continue to represent only the seller in the transaction. Option B. Obtain informed written consent from both the seller and the prospective buyer to engage in dual agency, clearly outlining the implications and limitations of this relationship. Option C. Proceed with representing both parties, assuming that the licensee's ability to be fair and impartial will suffice without formal disclosure or consent. Option D. Inform the seller and the buyer verbally about the dual agency situation and proceed with the transaction, relying on the verbal understanding. Correct answer is B. Obtain informed written consent from both the seller and the prospective buyer to engage in dual agency, clearly outlining the implications and limitations of this relationship. Explanation. This scenario presents a professional challenge due to the inherent conflict of interest that arises when a real estate licensee attempts to represent both the seller and the buyer in the same transaction without proper disclosure and consent. Kansas Real Estate License Act, specifically K.S.A. 58-3061, mandates that licensees owe fiduciary duties to their clients. These duties include loyalty, disclosure, obedience, confidentiality, accounting, and reasonable care. Attempting to serve both parties simultaneously without clear, informed consent fundamentally compromises the duty of loyalty and the ability to provide undivided representation to either party. The correct approach involves full and timely disclosure of the agency relationship to all parties involved. In Kansas, a licensee acting as a seller's agent owes specific duties to the seller. If the licensee also wishes to represent the buyer, they must obtain informed written consent from both the seller and the buyer to engage in dual agency. This consent process, often facilitated through a written dual agency agreement, ensures that both parties understand the limitations of the representation and agree to proceed. This approach is correct because it adheres to the Kansas Real Estate License Act's requirement for transparency and informed consent, thereby protecting the rights and interests of both the seller and the buyer while mitigating the licensee's risk of violating fiduciary duties. An incorrect approach would be to proceed with representing both parties without obtaining explicit written consent for dual agency. This failure to disclose and obtain consent violates the licensee's fiduciary duties to both the seller and the buyer. Specifically, it breaches the duty of loyalty by placing the licensee in a position where their actions may benefit one party at the expense of the other, and it undermines the duty of disclosure by withholding crucial information about the agency relationship. Such conduct can lead to disciplinary action by the Kansas Real Estate Commission, including license suspension or revocation, and potential civil liability. Another incorrect approach would be to unilaterally decide that representing both parties is acceptable because the licensee believes they can be fair to both. This subjective assessment ignores the legal and ethical requirements for informed consent. The law does not permit licensees to determine their own standard of fairness in dual agency situations. It mandates a specific process of disclosure and consent. Failing to follow this process, even with good intentions, constitutes a regulatory violation. A final incorrect approach would be to only verbally inform the parties about the dual agency situation. While verbal communication is a step, the Kansas Real Estate License Act and established professional practice require written consent for dual agency. Verbal agreements are difficult to prove and do not provide the clear, documented understanding that is necessary to protect all parties and the licensee. This failure to secure written consent leaves the licensee vulnerable to claims of misrepresentation and breach of fiduciary duty. Professionals should approach situations involving potential dual agency by prioritizing transparency and adherence to regulatory requirements. The decision-making process should begin with identifying the potential for conflicting interests. If dual agency is contemplated, the licensee must immediately consult the Kansas Real Estate License Act and relevant agency agreements. The next step is to provide full written disclosure to all parties about the nature of dual agency, its implications, and the limitations on the licensee's fiduciary duties. Only after obtaining informed written consent from all parties should the licensee proceed with representing both the seller and the buyer. If consent cannot be obtained, the licensee must choose to represent only one party or withdraw from the transaction. Question 19. The audit findings indicate that a mortgage application you are assisting with in Kansas contains a significant discrepancy between the borrower's stated income on the application and the supporting documentation provided by their employer. You have confirmed the documentation is accurate and the application information is incorrect. What is the most professional and legally compliant course of action? Option A. Proceed with the application using the incorrect income figures, assuming the lender will discover the error during their own verification process. Option B. Immediately inform the borrower of the discrepancy, explain the implications, and work collaboratively with both the borrower and the lender to correct the application with accurate documentation. Option C. Attempt to adjust the application figures to align with the supporting documentation without informing the borrower or the lender of the original error. Option D. Inform the borrower of the discrepancy and advise them to contact the lender directly to resolve the issue, disengaging from further involvement in the correction process. The correct answer is B. Immediately inform the borrower of the discrepancy, explain the implications, and work collaboratively with both the borrower and the lender to correct the application with accurate documentation. Explanation. The audit findings indicate a potential ethical lapse in handling a mortgage application, which is professionally challenging because it requires balancing client needs with strict regulatory compliance and maintaining the integrity of the mortgage lending process. The scenario demands careful judgment to avoid misrepresentation and ensure all parties are acting on accurate information. The best approach involves immediately and transparently communicating the discovered discrepancy to the borrower and the lender, providing clear documentation of the issue, and collaborating with both parties to rectify the situation. This is correct because it upholds the ethical duty of honesty and full disclosure to all parties involved in the transaction, as mandated by Kansas real estate and mortgage lending regulations. Transparency prevents potential fraud, ensures the borrower understands the implications of the inaccurate information, and allows the lender to make an informed decision based on correct data. This proactive and honest communication aligns with the principles of fair dealing and professional conduct expected of licensed professionals in Kansas. An approach that involves attempting to fix the application without full disclosure to the borrower or lender is incorrect. This constitutes misrepresentation and potentially fraud, violating Kansas statutes that prohibit deceptive practices in real estate transactions. It undermines the integrity of the application process and exposes the licensee to severe disciplinary action. Another incorrect approach would be to ignore the discrepancy and proceed with the application as if no issue existed. This failure to disclose a material fact is a direct violation of ethical obligations in Kansas law, which requires licensees to act in good faith and with due diligence. It places the borrower at risk of loan denial or unfavorable terms and exposes the lender to significant financial risk due to incomplete or inaccurate information. Finally, an approach that involves blaming the borrower for the inaccurate information without offering a collaborative solution is also professionally unacceptable. While the borrower may have provided the initial incorrect data, the licensee has a responsibility to ensure the accuracy of information presented to the lender and to guide the borrower through the correction process ethically and professionally. This approach fails to demonstrate due diligence and a commitment to facilitating a compliant and fair transaction. Professionals should employ a decision-making framework that prioritizes transparency, honesty, and adherence to regulatory requirements. When a discrepancy is identified, the immediate steps should be to verify the information, understand its impact, and then communicate clearly and promptly with all affected parties, seeking their input and collaboration to resolve the issue in a compliant and ethical manner. Question 20. The audit findings indicate a discrepancy in the prorated property taxes for a residential sale in Wichita, Kansas. The seller has provided a figure for their share of the annual property taxes, which, when calculated based on the closing date of October 15th and the annual tax bill of $3,600, results in a lower amount than what the buyer's agent calculated. The buyer's agent calculated the seller's portion of the taxes from January 1st to October 15th. Assuming a standard year with 365 days, what is the correct prorated amount the seller is responsible for, and how should the licensee proceed to ensure the purchase agreement accurately reflects this? Option A. The seller is responsible for $2,700. The licensee should inform the buyer that the seller's figure is incorrect, but proceed with the closing using the seller's figure to maintain goodwill. Option B. The seller is responsible for $3,000. The licensee should accept the seller's provided figure to avoid delaying the closing. Option C. The seller is responsible for $2,958.90. The licensee should advise the buyer to pay the difference to the seller after closing to rectify the error. Option D. The seller is responsible for $2,700. The licensee must ensure the purchase agreement is amended to reflect this correct proration, explaining the calculation to both parties. The correct answer is D. The seller is responsible for $2,700. The licensee must ensure the purchase agreement is amended to reflect this correct proration, explaining the calculation to both parties. Explanation. This scenario presents a professionally challenging situation because it requires a real estate licensee to navigate a potential conflict of interest and ensure compliance with Kansas real estate contract law, while also upholding ethical obligations to all parties. The challenge lies in accurately calculating prorations and ensuring the contract accurately reflects the agreed-upon terms, especially when a seller might be attempting to misrepresent the property's financial obligations to their advantage. Careful judgment is required to prevent financial harm to the buyer and to maintain professional integrity. The best professional approach involves meticulously calculating the prorated property taxes based on the closing date and the annual tax amount, then ensuring this calculation is accurately reflected in the purchase agreement. This approach is correct because Kansas real estate law, specifically concerning contract enforceability, requires contracts to be clear, unambiguous, and to accurately represent the agreement between parties. Prorating expenses like property taxes is a standard contractual element, and any misrepresentation or inaccurate calculation can render the contract voidable or lead to disputes. Adhering to the exact figures and clearly documenting the proration in the contract protects both the buyer and seller by ensuring transparency and fairness. An incorrect approach involves accepting the seller's stated prorated amount without independent verification. This is professionally unacceptable because it fails to exercise due diligence and could lead to the buyer overpaying for property taxes. It also violates the ethical duty of honesty and fair dealing owed to all parties involved in a real estate transaction. Furthermore, it risks creating a contract with a material misrepresentation, which could have legal ramifications for the licensee and the transaction. Another incorrect approach is to simply ignore the discrepancy and proceed with the closing as if the seller's figure is correct. This is professionally unacceptable as it demonstrates a lack of attention to detail and a failure to identify and rectify potential errors in contractual terms. It exposes the licensee to liability for negligence and breaches their fiduciary duty to ensure the transaction is conducted ethically and legally. A final incorrect approach is to confront the seller aggressively and demand they change their figure without presenting a clear, calculated alternative. While identifying the error is crucial, the professional approach involves presenting factual, calculated evidence to support the correct proration. This confrontational method without substantiation can damage the professional relationship and hinder a smooth closing, while failing to educate the seller on the correct procedure. The professional decision-making process for similar situations should involve 1. Identifying all financial obligations that require proration, e.g., property taxes, homeowners association dues, rent. 2. Obtaining accurate figures for these obligations from reliable sources, e.g., county tax records, HOA statements. 3. Performing precise mathematical calculations for prorations based on the agreed-upon closing date. 4. Clearly documenting these prorations in the purchase agreement or a separate addendum. 5. Communicating these calculations and their basis to all parties involved. 6. Seeking clarification or correction if any figures appear inconsistent or incorrect.